Hi everyone, this is Pennsylvania attorney Evan Gutman again, presenting video number 2 of my video legal education series that is based upon my book, State Bar Admissions and the Bootlegger's Son. The full book is available on my websites. I have 2 websites. One is heavensadmissions.com and the other is gutmanvaluations.com. Those websites also contain a supplement to the book, as well as a fictional novel I wrote that is titled Heaven's Admissions Process. Kind of compares the criteria for being admitted into heaven with the criteria to become a lawyer. The focus of my books, as well as this video series, is on the good moral character requirement to obtain a law license. The book also covers several other controversial areas of the legal profession and judiciary. So here we go with video number 2. Today, I'm going to talk about the concept of whether a law license is a right or a privilege. So if you're someone who went to law school, you meet that aspect of the objective criteria. Then, however, the board needs to determine whether you have sufficient good moral character to be an attorney. Now, certainly a lot of people feel that just the concept of assessing an individual to whether they have good moral character to be a lawyer is somewhat of an oxymoron. Most people tend to believe lawyers in general do not have good moral character, so whatever is the basis they're utilizing to determine whether they have good moral character, the overwhelming majority of the public probably feels they're not doing too good a job at it. Nevertheless, you are required to have good moral character, and it does need to be assessed in order to determine whether you're entitled to a law license. But the question is whether the license itself, in assessing good moral character, whether obtaining the license is a right, a constitutional right, or a privilege. Now, you might say, what's the difference, whether it's a right or a privilege? The difference is, in one manner, esoteric in nature, kind of obscure, and in another manner, it actually has a somewhat concrete importance. From an esoteric viewpoint, the concept of a right in any area means you're entitled to it. It's yours. If you want it, you can exercise it, you can do it. It's your right. The concept of something being a privilege, in contrast, means it's something where we're going to give it to you maybe in our grace and our favor if we want to. If we don't like you, we're not going to give it to you if it's a privilege. But if we like you, we'll give it to you, and don't forget to say thanks to us and appreciate it. But if it's a right, then you're entitled to it. Even then, even if it's a right, there's still certain restrictions that can be imposed upon that right, but you certainly have a much, much greater degree of entitlement to it if it's a right versus a privilege. So, how do the states look at it? How does the U.S. Supreme Court look at it? We're going to talk today about several cases. I'm going to provide you with some quotes. The U.S. Supreme Court actually squarely addressed the issue as to whether it's a right or a privilege as early as 1866 in the case of Ex parte Garland, which occurred right after the Civil War. The U.S. Supreme Court wrote as follows: "The attorney and counselor, clothed with his office, does not hold it as a matter of grace and favor. The right which it confers upon him is something more than a mere indulgence." So the U.S. Supreme Court squarely said at that point in time it's a right. Moving forward years later, in 1971, the U.S. Supreme Court handed down 3 key bar admissions cases on the good moral character issue, which were Baird, Stolar, and Law Students Civil Rights Council versus Wadman. In Baird, the U.S. Supreme Court wrote as follows: similar to Garland, "The practice of law is not a matter of grace, but of right for one who is qualified by his learning and moral character." Moving forward after that, in 1985, In the case of Supreme Court of New Hampshire versus Piper, the U.S. Supreme Court wrote as follows: "The lawyer's role in the national economy is not the only reason that the opportunity to practice law should be considered a fundamental right." Now, here's where it gets dicey. As I indicated, from an esoteric, obscure perspective, the concept of right versus privilege is just whether it's something you're entitled to or whether they're giving it to you as a matter of grace or favor. As a practical matter, though, what it really does from a concrete perspective, whether it's a right or a privilege, is determines the scope of the questions that the state bar can ask of you. Because if it's a right, it's subject to one standard of assessment with respect to state bar questions, and if it's a privilege, it's subject to a much more lenient standard. Now, I just cited 3 cases here that the U.S. Supreme Court handed down where, to me at least, it seems they squarely said it's a right. The state bars do not treat it as a right. As a practical matter, virtually every single state bar today treats it as a privilege. And this has been a hotly contested area. In 1971, when the U.S. Supreme Court handed down those 3 cases, Baird, Stolar, and Law Student Civil Rights Council versus Wadman, the U.S. Supreme Court ruled in favor of the applicants that the state bar question was unconstitutional in the case of Baird and in the case of Stolar. But in the more broad case where the litigants were challenging the overall scope of the questions, the court ruled in favor of the state bar. So far as I know, that is the last time the U.S. Supreme Court addressed the good moral character issue on February 23rd, 1971 in 3 cases, which, taken in conjunction with each other, really decided nothing whatsoever. The cases, all 3 of them, were decided by 5-4 opinions, and the 2 that the applicants won seemed to suggest that, it should be considered a right, but then the bar won the bigger case, Law Students Civil Rights Council versus Wadman. So those 3 cases in 1971, which really resolved virtually nothing, they stand today and really have not provided much guidance. As stated, the state bars tend to treat it as a privilege. Along these lines, let me give you read a few cases at the state level, where basically they indicated that we're not even going to give you a guideline rule, or we're not even going to give you an articulable standard. We're just going to kind of do what we want on a haphazard basis. In one case, a state case, the court wrote about the applicant, and this is actually, the court wrote about the applicant, petitioner's jury acquittal. A jury acquittal. Petitioner's jury acquittal has special significance with regard to the board's conclusion that petitioner lied 3 times in asserting her innocence. So in other words, even though she was acquitted, they're treating the applicant as if they were convicted. And they're saying that basically by asserting she's innocent, even though she had an acquittal, she's lying. In another case, a dissenting opinion to delineate what the majority did presented the majority's viewpoint as follows. Now, this is in the dissenting opinion writing about the majority's opinion. The dissent wrote, and this is actually kind of funny, "I think the contempt conviction is too unimportant to stand in the way of his admission, especially when this court, over 2 dissents, including mine, saw fit to admit 3 convicted felons, a murderer, a bank robber, and a drug pusher." So a murderer, a bank robber, and a drug pusher got in, but a person who's got a contempt was denied admission. By the way, the citations for all these cases are in the PDF that accompanies this video, as well as in the book. So if you want to basically see the citations to the case, as well as my commentary on the cases, you can take a look at the PDF. It's in the section titled Memorable Quotes from Bar Admission Cases. Another case, a state court wrote, the dissent, once again, because the dissent basically is the one that points out where the majority is way off base, in my view, at least. I agree with the dissenting opinions in these cases, but nevertheless, they are dissents. The majority decided it the other way around. So the dissent, in criticizing the majority, wrote, "The only way this court could have been advised, therefore, was through an informal communication. The possibility that this unusual proceeding was initiated on the basis of rumors and gossip turns the entire admission process into a sham." Another dissenting opinion in another case wrote, once again, these cases are, citations are in my books. Just go to the memorable quotes from bar admissions, which is in the first section. Also, it's in the PDF here. "Applicant will not be permitted to practice law in this state, not because he failed to follow the rules, but because we have." Another case, which is a somewhat humorous statement that the applicant made, and the applicant apparently did not put on his application that one of his prior residences was being in the penitentiary. And in explaining it, I kind of like this. The applicant stated, "I had no reason to believe that the U.S. federal penitentiary was a residence of mine. I never considered it a residence." Another case in criticizing the majority, the dissent writes, "Until today, being obnoxious and being hard to get along with were not grounds for the extreme sanction of denial of admission to the Nebraska bar. The majority reaches far beyond the current rules governing admission." The majority in a case, different case, the majority wrote, "He does not outright lie about such matters when questioned, but he is inclined to pass them off with glib, equivocal answers which put him in the best light." In other words, he's not lying. They're saying he's not lying, but they just don't like the way he's telling the truth. Another case from Texas, actually, the court wrote, "The board claims that," that's speaking about the State Bar Admissions Board, "the board claims that it was empowered to deny his application not for the content of his answers, but instead for the way he answered." And I think the last one I'm going to read here is in another case. The court wrote, "Finally, respondents maintain," this is speaking about the bar, "finally, respondents maintain that they are allowed to question applicants about any matter which they deem relevant to good moral character. The implication is that respondents have absolute discretion in determining what constitutes good moral character." I spoke a little bit earlier about the Baird case, and I just want to finish up with this, revisiting the Baird case, because it goes back to the issue of right versus privilege. And although the court referred to the majority opinion of the U.S. Supreme Court in the Baird case from 1971, referred to the practice of law as being a right, Justice Harry Blackmun wrote a dissent in that case because he didn't agree with the majority. And it's quite interesting what he wrote. He wrote as follows: "There is talk, of course, in the briefs here about whether admission to the bar and receiving authority to practice law is a right or a privilege. I am old enough and old-fashioned enough always to have regarded it more as a privilege than as a right. A century ago, Mr. Justice Field referred to the practice of law by a qualified person as a right and not as a matter of the state's grace or favor. The Arizona court has spoken in similar terms. The characterization of bar admission as a right or a privilege may be little more than an exercise in semantics." Now, when Harry Blackmun wrote that in 1971, there was merit to what he was saying about it being largely an exercise in semantics, or more along the esoteric difference that I was talking about regarding right versus privilege. But what happened is, subsequent to 1971, the manner in which the court determined constitutionality of various laws and statutes for equal protection clause and First Amendment analysis was expanded from just rational basis scrutiny to also including various levels of intermediate scrutiny. Previously, you only had rational basis scrutiny, and then for issues pertaining to race, you had strict scrutiny. But since then, it's been expanded to significantly other levels of scrutiny. As a result, it's a lot more than an esoteric difference today. It's a very concrete difference that addresses the importance of how the questions are assessed, and therefore it is very critical today from a practical matter as to whether the ability to engage in the practice of law is a right or a privilege. Hopefully you found that interesting. We'll see you hopefully in a day or two, a few days, for video number 3. And remember, love right, don't fight. Bye, everybody.